JP, thanks again. Now, a number of practitioners with whom I've had conversations, lawyers talk discussing matters that are in the public domain, especially that affect the legal profession. We discuss these things, and you'll find people on one side and other people on the other side. So when you say you were cleared by the JCT, that's factually correct, yes.
Yes.
But then later there was a review application in the High Court, and subsequently a review of that decision.
That's right.
In the High Court, and subsequently all the way to the
Supreme
Court of Appeal. My recollection, correct me if I'm wrong, was that the Premier of the Western Cape went there to challenge the composition because she wasn't present when the decision was made, and the Constitution says she must be present, or a Premier of the province relating to the judges.
That's right, and she was successful in that.
She was successful there.
Yes.
And Freedom Under Law went there to say the decision of the JCT was irrational, it must be set aside. The SCA agreed with it and said the matter must go back to the Judicial Service Commission for you to be cross-examined and so on. And so you were cross-examined, as you say, you were, continue the statement?
Well, I was cross-examined. This was now the second hearing before the Judicial Conduct Tribunal. The question that we must ask ourselves is this: having been thoroughly cross-examined pursuant to the ruling of the SCA, what did that cross-examination achieve? Certainly I was not destroyed in cross-examination. If anything, I stood firm, and my evidence or my version has not changed. It has been the same since May 2008. On the other hand, Judges Ngabinde and Jafta are consistent. They were not complaining then, they are still not complaining now. They also changed their version. The version that they ran with for the past 12 years changed. In a situation like that, I certainly expected, and most people, fair-minded people, would have expected me to be acquitted. Because not only that the version of the two judges has now disintegrated, but I was cross-examined thoroughly on certain aspects as pursuant to the ruling of the SCA, and I did well in cross-examination.
Now, for those who may not be aware about what the different versions are, would you care to just elaborate, just give examples of what the version of the one judge was before and what it then later became?
Well, it transpired that there was some kind of interference with the recording, and this was highlighted by Tandi Norman SC in the course of the hearing last year. Basically, the judges of the Constitutional Court ran with a version that I said the finding must be Sestembelenina, meaning that you must find for Zuma, which version they did not change, right? They said Sestembelenina meant that they must find for Zuma. But the hearing, as I understand it, certainly Judge Jafta's version is not what it was, because they asked for the record to be amended and they deleted reference to Zuma. And I think the other thing related to improper influence, that also changed. It was no longer improper influence, it was attempting to influence improperly. So there were changes in their version. And they were not just typographical, but they were material. You cannot run with one version for 12 years and then on the eve of the hearing, you change that.
Okay, well, I hope it's clear for the people who never understood exactly what it is that you're talking about the change in version and so on. Now, but let me ask this final question on this issue. Even considering that your view is that you were cleared,
yes,
and there is no reason, in your view, that you shouldn't be elevated to the position of being leader of the judiciary in South Africa. Can I put this question to you? as an officer of the court, not me as both me as an officer of the court and you being the officer, the uber officer of the court, if you like, as one of the leaders in the judiciary. Isn't the issue a perception one? Because even if it's true that you were cleared,
Yes.
the perception is that there is still the cloud hanging over you, although you've taken the decision on review in the courts, as I understand it.
Yes.
But a leader of the judiciary who still has this question hanging over him should not have accepted nomination to be a leader of the judiciary, because what happens if the review is thrown out? And now you are the Chief Justice.
Well, if the review is thrown out and I've already been appointed as Chief Justice, the law would follow its course. It would obviously mean that the law would follow its course. But I see no reason why that should stand in my way of throwing my hat in like anybody else. But as I've said before, I'm not the only judge who's facing charges, right, of gross misconduct in this country. And some judges have been promoted despite that. I've already alluded to the fact that among the candidates nominated for the big job, there is Dunstan Mlambo. He is facing serious charges, and everybody knows that.
All right. Now, assuming that you are appointed, well, let me ask this first. With all this debate going on about the propriety of you accepting the nomination to be Chief Justice, what do you think personally are the prospects of your being shortlisted, for one thing, and secondly, being appointed as Chief Justice?
Thank you, Mr. Ngalwana. Prospects of being shortlisted, I think they are good. If you look at my track record, let us take this division. I've been running this division since the 1st of May 2020. Notwithstanding, 1st of May 2000.
Yes.
Notwithstanding the so-called controversy and cloud which is being generated, this division is one of the best performing divisions. A fact which has been acknowledged even by the Department of the Office of Chief Justice, OCA. Right? It's well run, and I'm doing that literally single-handedly. But not only that, in terms of transformation, we're a leading division. Look at the number of black judges here, and I'm using the word black generically to include everybody. Also look at the number of women. So I've already done work that demonstrates clearly that if I'm given the opportunity, certainly I'm going to push the transformation agenda. But it goes further than that. I think I'm the only judge president in this country who sat with a group of colleagues in this division. We identified a problem, namely, we tend to concentrate too much on practitioners who have already been prepared by the profession in terms of nurturing acting judges. But we ignore young and upcoming practitioners who are just joining the bar. 3 years ago, we have been doing it consistently almost every year. We said we're a group of judges, about 7. We identified young practitioners between their 1st and 3 years at the bar. And the attorney's profession, we invited them to an open court. We ran a series of workshops on different aspects of the law. How to conduct motion court, how to deal with trials, how to raise objections in courts, the ethics. We did everything single-handedly. It has made a huge difference based on the feedback that we're getting. I mean, if you go to that division, you practice law here yourself. There's a big difference. You walk into a court now, it is not what it was 12, 13, 14, 15 years ago. You're seeing a number of young women staying in the profession, and I welcome that development. So we do all of that.
So for the benefit of those who may not be familiar with the terminology, 3rd division is unopposed.
It's unopposed motion court, yes. We call it 3rd division. It's unopposed motion court.
Yes.
where we deal with unopposed divorces, unopposed applications for sequestration, liquidation, you name it. But it's generally unopposed applications.
And the most important standard to meet is to ensure that your papers are in order.
Papers must be in order at all times, and I also spend a lot of time with aspirant judges, people who are acting in ROS, nurturing them. And that is reflected. One looks at the quality of judges that the Western Cape is producing, despite all the so-called cloud and problems that are created. One looks at the quality of judges. Some of them are going to the SCA, others are already in the SCA. I mean, people like Lord Dumisani's only, they were all judges in this division. Ashton Skippers, they were all judges under me, and I have now produced them and forwarded them to the senior court, to senior courts, notwithstanding the cloud that is deliberately generated by the newspapers.
Talking about the third division, unopposed motion, there's an anecdote I have to share. I would never forgive myself if I didn't.
Yes.
While I was practicing here, there was Judge Fallon.
Oh, Ian, yes.
Ian Fallon, when he sat in third division, and junior counsel stood up and made a submission that I submit that the papers are in order, and I move for an order in terms of prayers 1, 2, and 3. And if it is covered that there was something that was not in order, say for example, there's no return of service by the sheriff,
That's right.
the summons or whatever, the application was served on the respondent who hasn't showed up, his sanction to counsel was to cake them.
Oh, yes, yes.
So he orders them to buy cake for the entire floor so that you never do that again, which I thought was a good practice.
It is a good practice. I had to cake someone, an advocate. You remember the rule, Mr. Ngalwana? In court, it's the rule, I'm sure, even in Joburg. An advocate must ensure you do not leave just one counsel with a judge in court. And there's a reason for that. The judge may want to engage counsel and may need assistance from another one. I did that 3 weeks ago when I called the roll in third division. One counsel just walked out. I called her. I said, look, this is the rule. You made the rule. Buy cake for us. And I said, no, I don't like the cake. I want biltong. The rule is still there, and there is a reason for it indeed. Thank you.
Good. Right. JP,
Perhaps
the last question on this segment is, if you were to be appointed Chief Justice, what is the one attribute
that I will do differently?
Yeah, that sets you apart from everyone else. The one thing that no other judge is capable of doing. Let me put it that high.
Right, thank you, Mr. Ngalwana. I have looked very closely at the contribution that Chief Justice Mogoeng made. One must give him credit. He led the judiciary in difficult times, but he concentrated more on laying a foundation for administration. For instance, we have norms and standards in place. Before he took over, we did not have that. We have a separate department called the Office of the Chief Justice. Gone are the days, for instance, whereby judges would reserve judgments for years. Credit to Chief Justice Mogoeng. The system is in place. He is leaving behind him a good system in place which is efficient. Right. But I ask myself, what contribution will I make? I think 3 things. I want to take transformation to a different level altogether, which is unprecedented. Push the envelope as far as you can go. We have already started doing that by saying, look at the bar and the attorney's profession, but don't just start looking at that. Identify problems. Why are we not retaining enough men and women on the bench? It goes back to university level, but it also goes back to making sure that newly appointed lawyers who are new to the profession must be nurtured. They must be given work. We must transform the briefing patterns and make sure as judges that those lawyers have work, but not only that they have work, they know what to do. Make the place friendly and user-friendly to them, especially women. The other area where I think I would concentrate on is jurisprudence. I'm often ridiculed when I say common law is not a true reflection of the South African of the culture of the South African people. Let the truth be told. When we were colonized by our colonizers, we had our own systems of law in place. We were colonized and the common law was superimposed upon us. But there are instances where, in my view, the continued use of common law has created a wedge between the Constitution and the rights of the subjects. I'll give you one example. For me, I have problems with the principle of subsidiarity, which the court alluded to in my vote counts case. My understanding of that principle, if you want any protection in South African law, you go to the common law first. If there is an existing principle in common law, it offers adequate protection, don't even mention the Constitution. For me, it's the other way around. Go to the Constitution. You should be able to go to court, Mr. Ngalwana, and say, here is a Constitution. In the context, for instance, of housing, you should be able to go to court and say, here is a Constitution, Judge. In terms of Section 10 thereof, the right to dignity is guaranteed. In terms of Section 26 of the Constitution, the right to housing is guaranteed. This client of mine doesn't have that, and this is a violation of the Constitution. You'll be able to get the results quicker. Whereas if you go to common law, it is a wedge, it's a serious layer between the Constitution and the rights. If you go to common law, you'll have to prove, number one, that the person who brings the application is a valid title owner, and all those requirements. So for me, the preeminence of common law remains a problem. It presupposes that it was flawless, whereas for me, it's a system that was imposed on us. The same common law, we'll have to revise it at a quicker rate than we are doing now.
But as Chief Justice, you wouldn't be able to change that, because then it means the Constitution has to be changed, because the provisions to which you refer to legislation that has to be implemented or enacted in order to give effect to the constitutional right. So that means that question must go to Parliament. How would you effect that change as a Chief Justice?
Well, there are a number of ways of doing that. First of all, I still struggle to understand why in this day and age, in 2021, in order to interpret the legislation, I must look at the judgment before 1994. That is the starting point, right? Judgments prior to 1994, in my view, are of limited value in terms of interpreting the rights that are guaranteed in the Constitution.
JP, can I stop you there? Because that's a pregnant statement. Can we take that up in the next segment?
Yes.
Right where we were.
All right.
Okay.
They are of limited value. We should be concentrating on the Constitution and moving forward. We need a Constitution to create a new human rights culture, which did not exist at common law.
We'll take that up in the next segment.
By all means.
Thank you.